Good afternoon. First of all, thank you very much for the invitation and for the opportunity to speak about unit-linked policies and the problems that the consumers faced in Poland. Okay, first, a few words about the Polish Insurance Ombudsman. If I'm correct, you don't have that type of institution in Romania so far. However, due to the fact that we have the directive on the ADR, which was published last year, probably this will change very fast. The Polish Insurance Ombudsman has 20 years almost of the tradition of representing consumers, not only policyholders, beneficiaries of life insurance, but also victims of car accidents. And that is, I would say, a specific type of help that is not that common for other ombudsmen in the European countries. We represent consumers and non-consumers, and our main task is the alternative dispute resolution of complaints. Last year we had over 16,000 of complaints coming in. But not only complaints, we have other tasks, issuing legal opinions of legislative proposals, informing the supervision authority about unfair practices of insurers, intermediaries, and of course education of consumers. However, unit-linked insurance in Poland was quite problematic due to the fact that the practice of unit-linked changed during the last years. We started in 1995 with, let's say, very well-known life insurance with only a small supplement of an investment, and that type of contracts evolved into strict investment products with almost no life protection, and the whole premium paid by the consumer was invested into insurance investment funds, and also the amount paid to the beneficiary in case of death or the termination of the agreement was no more than the premium paid in, or additionally some income if there was any from the investment. New unit-linked insurance products in Poland introduced a new feature, which was a liquidation fee. So if a consumer quit the agreement before its final date, the liquidation fee was calculated from the premiums paid, and the consumer received only a part of the amount paid in, and sometimes lost all of his money because in the first year of the insurance contract, the liquidation fee was 100%, even more. So all the money paid in due to the fact that the contract was terminated was lost, so the consumer received no money. Formally, this liquidation fee decreased within next years to 90%, 80%, 70%. However, that fee was calculated from the premiums paid, so if you check the amount that was taken from the account of a consumer, the fee did not decrease, but it actually increased. It only decreased in numbers. So if a consumer looked at the paper, he thought, yes, the fee is decreasing. Well, actually, he was paying more and more each year. We also identified high commissions paid to intermediaries for selling unit-linked products. Usually, that was the total amount of a one-year premium. So that was kind of the issue that we discovered after looking into the unit-linked insurance policies. In 2011 and 2012, the Polish Insurance Ombudsman received more and more complaints. Well, the numbers are not very high, 146 complaints in 2011, 2012 it was 516 complaints, but all the complaints were quite the same. They were stating the same problems. Consumers were complaining about misstatements of intermediaries, non-disclosure of information about liquidation fees, non-disclosure of information on the risk of the investment. Consumers, however, were informed about high profits of such contracts, usually 10%, at least 10% per annum, and even more. Consumers were also informed that they were buying not in an insurance agreement, but that they were placing the money into a safe deposit. That was the problem because most of the consumers that bought insurance agreements bought it in banks, so they were quite sure that that is a safe deposit, and even if they saw an information about insurance, they were usually convinced that this is a safe deposit additionally insured, or this is what they were told they are paying into. Consumers that resigned from the agreement lost all their money due to the liquidation fees, and sometimes that money was very, very high. So after reviewing the complaints that we gained, we identified unfair selling practices, but also problematic issues regarding the construction of the products. The Polish Insurance Ombudsman doesn't have much competence to make any fines for the insurance companies, nor do we issue binding decisions. That's why we decided to prepare and publish an in-depth report. This report was published in December 2012. It was obviously very big, 144 pages. And this report was submitted to the Polish Supervision Authority, to the Competition and Consumer Protection Office, to the Polish Prime Minister, Polish Ministry of Finance, and other institutions that can take action due to the fact of the problems with unit links. Our report identified some unit-linked insurance as strictly financial instruments that should not be distributed by insurance companies. The report also identified the common practice of mis-selling of these products in banks and so-called independent financial advisors' offices. We also identified violation of IMD directive and the supporting Polish provisions, as unit-linked insurance were offered in the form of a group insurance. Therefore, no qualifications was needed to sell the unit-linked insurance. Consumers were actually not parties to the insurance agreement, but they were members of a group scheme. So there was a limitation of many rights for the consumers and also limitations of the obligations of the seller of such a product. And there was, of course, lack of responsibility for mis-selling because formerly there was no selling of an investment product. We also identified the use of unfair contract terms that were previously banned by the Polish Consumer Court. It was about the liquidation fee, to be precise. The report also identified the problem of overpricing of the initial value of an investment fund unit, and that was a problem that could have been seen only by checking many complaints. We saw that people bought the fund units for prices that were never on the stock market. We also identified some unit-linked insurance as highly complicated and not designed for average consumers. Many complaints identified loss of millions of Polish zlotys. We also identified, in fact, 2 insurance companies with the most unfavorable products. So we didn't say in the report that all unit-linked insurance is bad, but we saw the products that were really complicated and shouldn't be sold to consumers. Of course, the report requested actions of the competent authorities. The results of the report were actually what we wanted it to be. It was the first public information on unit-linked insurance, on new unit-linked insurance in Poland. Until the report, nobody was speaking about that product in a negative or an objective way. There were always positive information on unit-linked. But we also had allegations and threats of the insurers, including an information that our report should be banned or should be taken out of our internet website. But it was still an impulse for actions of competent authorities. And some actions were actually undertaken. The first one was the letter of the Polish Supervision Authority to the Ministry of Finance, in which the authority approved our report and stated a proposal for amendment of provisions concerning group insurance. We also had a draft proposal of the soft law on information practices, including introducing a key information document that was prepared by the Polish Association of the Insurers. A very interesting effect of our report was the decision of the Competition and Consumer Protection Office issuing a fine on one of the banks involved in selling unit-linked insurance policies. We also had a draft proposal of the Polish Supervision Authority of soft law on bank assurance, introducing some information obligations related to unit-linked insurance, but also, and that is very important, prohibiting banks to accept high commissions from insurers in group insurance. This draft proposal, this soft law, is to be enforced as of May 2014. We also experienced first 2 class actions against insurance in Poland. Class actions is not very popular in Poland as it was introduced only in 2009. So far we had no class actions against insurance. However, unit-linked changed that. Insurance Ombudsman is providing a legal opinion to the court for this procedure. We don't have the judgment yet, and we don't know how long will it take to get the verdict on that. The report also resulted in a positive way. More complaints were resolved in favor of consumers, so banks and insurers are now more willing to settle disputes and return the money that was paid by the consumers. However, the number of complaints is still rising. In 2013, we had over 1,200 complaints, so the number of complaints had not decreased. We achieved greater awareness about unit-linked insurance among consumers. However, on the amount of premiums collected in 2013, they did not decrease. That means that still those products are sold, so the problems will probably still be on the market. Thank you very much for your attention.